One of the most common areas that we litigate today are not strictly trust and will cases, but the ownership and entitlement of beneficiaries to individual retirement accounts, other private retirement accounts, life insurance proceeds, joint bank accounts, payable and death accounts, stock and brokerage, survivorship rights, all of these types of issues. And again, this is an area of increasing litigation, and it's also complex because depending on who the beneficiary is, let's say for example it's a one sibling versus another sibling. You get into the issue of capacity and undue influence just like you would in a will or trust dispute, but oftentimes you get into this subtle area of gifts that are made out of joint bank accounts over time. And that creates huge questions of fact for the attorney to deal with, as well as the ultimate fact finder, whether it be a judge or a jury. So what we tell people is there is a presumption on joint bank accounts under the law that it belonged to the survivor. That presumption may be rebutted if there is capacity issue or there's other issues of undue influence or fraud. And we see that a lot. And the law is different for stock brokerage accounts as it is for joint bank accounts in an institution. So the attorney has to be sensitive to what type of account it is, because the law does differ on whether or not it's a joint bank account or it's a joint stock brokerage account. So these kinds of cases, they come up all the time. It's a heavy factual inquiry, and we've done many of these.